Welcome back to Ladies Can We Talk? This is Debbie Georgatos, and so happy you've tuned in. You know, we have a new clock on this show, and I don't have my floating breaks anymore, so I'm trying to be sure I give our guests sufficient time. I really appreciate having Robert Henneke of the Texas Public Policy Foundation on the last segment. He's a great guy. We'll have him on again. But now we have on the line just a very wonderful leader in Texas, one of the most respected conservative figures in Texas, Attorney General Ken Paxton. Hello, sir.
How are you doing?
Just great. It's great to have you. Well, I'm learning how short my segments are now, so I just want to jump right in. We're speaking to Attorney General Ken Paxton. So, General Paxton, you were up in Washington in front of the Supreme Court recently talking about the case involving the President Obama's, one of his executive orders, his executive amnesty order, which conservatives refer to it. And you were talking about whether or not the case was about whether or not the president had the authority to issue that executive order. So can you just go ahead and tell our listeners quickly what the case was about?
Yeah, so basically for about 6 years, from the time the president was running for office to August of 2014, the president said over 20 times that he did not have the authority to change immigration law because he was getting a lot of pressure to do that. And he made statements like, this is a democracy, Congress has to do this, I'm not a king, I'm not an emperor, I can't wave my magic wand. And then in November of 2014, he issued an executive order which made 4 million people that were here unlawfully under statute, he made them lawful, and his words were, I just changed the law. And so Texas sued, and 25 other states joined us, which is remarkable. And we sued basically saying the president doesn't have the statutory authority or the constitutional authority to make up law. This is all up to Congress. Congress has to pass the statute to change the law, and they didn't do that.
I like that. And actually, I will tell for our listeners, you know, it's an interesting time before the Supreme Court because there are only 8 justices after the recent very sad passing of Justice Scalia. So it's an interesting time to be in front of the court. And the lower court, if I have it correctly, General Paxton, a federal judge ruled in Texas's favor, and then the Fifth Circuit, the federal appeals court, the Fifth Circuit Court of Appeal, also ruled in Texas' favor. So far, the courts are agreeing with you that the president lacked the authority to issue this executive order, right?
That's correct. So far, we've won at the district court in Southern District of Texas, and we won through a procedural issue. And then at the Fifth Circuit, we actually won on the procedural issue, and we won on the statutory claim that the president didn't have the authority. And then at the Supreme Court, they were also addressing the constitutional claim. So at every level, it's actually gotten better, and they've considered more of our actual claims.
I love that. And I think this is such an important case. And, you know, I want to be sure for our listeners this is a little bit less about immigration. I mean, it does, of course, the immigration issue matters and the substance of the president's executive order matters. But the importance of the case is a little less about immigration and more about defining or constraining presidential power. Or at least that's how I see it. What do you think?
No, that's absolutely right. Obviously, there is some immigration policy in this, but fundamentally, this is a question of whether the presidents going forward have the authority to look at a statute and say, I don't like that statute. I know that I'm supposed to go through Congress, but I can't get it through Congress, and so I'm just going to change the law. And if he gets away with this, then what would stop another president if we had somebody that decided they didn't want people to have the ability to have, their Second Amendment? They just go in and change some rule, and it doesn't have to go through Congress. And it really makes Congress irrelevant and puts more and more power in the executive branch and in the agencies.
You know, I love that argument. I've said that many times on this show about the idea that even if you are a strong advocate for loosening immigration policy or for giving amnesty to everyone, no matter how they got here, you still should be on the side of Texas in this case because it really has such broad impact and potential impact on America's future. As you say, a president could come along, a very conservative president, issue an order that a liberal would find really unacceptable. But so it's the rule of law above the policy beneath it.
Well, yeah, and I think so many people get caught up in, well, I like the policy, and so I think Texas is wrong, and we're going to support this from being done. But, down the road, we could have presidents that people don't disagree with on anything. It could be something really awful for all of us. And if we perverted our Constitution to not mean that the president is limited to enforcing the laws, not making them, then we could potentially set up precedent for future presidents to do some really, really bad things that then these people who agree with the immigration policy would find themselves in a very bad situation, having changed the way we look at the Constitution and then ending up with a president that has absolute power.
Absolutely. Okay, I do want to change the subject a minute about the being up in the Supreme Court for this argument. I mentioned to our listeners before, I went to law school in Washington, and I was fairly nerdy, and I loved to go listen to the Supreme Court arguments. It used to be much easier to get in back in the olden days and listen, and I think it's just so interesting. There's such majesty to the court itself and to the idea of what's happening there. So I'm curious, being in front of the Supreme Court, first of all, were the justices really active, or did any of the justices really seem particularly interested in the case, or were all of them asking questions?
Well, your listeners may not know, but Clarence Thomas typically didn't ask questions, and he did not ask any questions. He is known for being very, very smart and reading all the briefs.
Yep.
Typically doesn't ask questions. All the rest of the judges were pretty engaged. We got questions from what you might call the liberal judges and the more conservative judges. And I actually thought it was really interesting because there were two key statements made. One was by Justice Roberts, who one of the things they were challenging Texas on was whether we had standing to bring our case, whether we could show some harm. He told the Solicitor General from the United States, who was arguing that we did not have standing, he said, look, losing money, which is what we claim through our loss of having to spend all this money on new driver's licenses, losing money is a classic case for standing. That was a statement by the Chief Justice. And then Justice Kennedy, on the actual merits of the case, made the argument to the Solicitor General of the United States, again saying something like, look, this seems upside down to me. Normally, Congress passes a law, the president implements it. In this case, the president changed the policy, and Congress is supposedly acquiescing in it by funding it, so it seems upside down. Those were statements, and those are statements that are favorable to us.
Oh, those are great statements. I love hearing that. And actually, just again, because it's such an unusual time with only 8 justices. So what happens if they split 4-4, because they can't come to a majority decision in this case?
Well, so we're actually hopeful that we'll get more than 4 because, as you noted earlier, this is a bigger deal than just immigration policy. But even if we don't, if it's 4-4, because we were successful in the Fifth Circuit, we would win on that basis. Now, all we're fighting over here is a preliminary injunction to stop the implementation of this program from going into effect until we actually have the trial on the merits. But it is a good sign because a preliminary injunction means that the court has said that they think that we're likely to win on the merits.
Exactly. And I was wondering how much I could get in the preliminary injunction part, which I actually, I mentioned to our listeners, we have a new clock, and I have to be very careful when I get cut off. But it is true, even if the court went 4-4, and so they are just affirming the Fifth Court's decision, and so it goes back to trial court, wouldn't the trial and the preliminary injunction last? Wouldn't it last into where we're going to have a new president?
I would suggest that that's very likely. I also would suggest that, if the courts rule in our favor on the preliminary injunction, the administration is going to have a big hill to climb winning the case in the end because, again, that means the judge has already said they're likely to win on the merits. Now, maybe there'll be something new, but I doubt it. I think we've got a really good chance of winning this case if we win at the Supreme Court.
I love that. I love it. I was going to tell our listeners we're speaking with Texas Attorney General Ken Paxton, a good friend of this show, a good friend of conservatives in Texas. And I will put up on our Ladies Can We Talk Facebook page an article that was written by General Paxton called Supreme Court Must Rebuke Obama's Self-Coronation by the Texas AG. It's a great column, and it kind of summarizes everything we're saying tonight. General Paxton, thank you so much for calling in.
Hey, I appreciate it. Thanks for having me on.
Thank you, and thank you for fighting for Texas. I just so appreciate that.